This is Bloomberg Law with June Grasso from Bloomberg Radio.
Juror drama at the Sean Diddy Combs trial even before deliberations begin. The judge dismissed juror number 6 yesterday, despite the defense's concerns that putting in a white alternate for the black juror would make the jury less diverse. And another juror may be in jeopardy for speaking about the case. Joining me is former federal prosecutor Robert Mintz, a partner at McCarter English. Bob, tell us what happened with juror number 6.
Even before we got to the close of the trial and deliberations in front of the jury, one of the jurors, juror number 6, was removed from the panel by the judge after it was determined that the juror had been less than candid about where he resided. During the jury selection process, he apparently indicated that he lived in the Bronx, which is part of the Southern District of New York, but later information surfaced that he actually lived with his girlfriend in New Jersey, which is not within the Southern District of New York and not even within the district where the trial is taking place. And the court rules say that you cannot be sitting on the jury unless you reside within the district. So that was grounds to remove the juror. And the judge found that there was nothing that could be done to repair the juror's credibility, since, according to the judge, he had apparently been less than candid about where he was living.
The trial is in its 6th week. Do the attorneys have a feel for which jurors may be leaning in their direction?
Throughout the trial, it's typical for the defense and the prosecution to be forming opinions about which jurors they think may be favoring their case. Of course, nobody really knows what's going on because the jurors aren't saying anything, but based upon their body language, perhaps based upon the eye contact that they're making with witnesses, eye contact they may be making with the defendant, just the way they conduct themselves in the jury box during the trial, it's inevitable that both the prosecution and the defense form some belief as to which jurors may be favoring them as the trial unfolds. In this case, when the judge decided that juror number 6 had to be removed, there was an objection by the Combs defense team saying that it would create a mistrial. This was only one of 2 black men that was on the panel. And in this case, what you had was the removal of a black middle-aged man who was now replaced by the alternate, who happened to be an older white man. The defense argued that that was unfair, that it created a racial imbalance in the jury, but the judge ruled that race is not something that he can consider in terms of removal of a juror. It's something that is beyond the scope of what is relevant for consideration as to whether this juror can continue to sit on the jury panel, and he therefore removed juror number 6 over the objections of the defense.
The judge saying that he can't consider race. Do judges, when they're seating a jury, consider the racial diversity of the panel?
Well, what the case law says is that you cannot discriminate against jurors based upon their race. So, for example, throughout what's called voir dire, which is a process by which both the defense and the prosecution select jurors, attorneys are allowed to ask various questions about potential jurors in order to determine whether or not they would like them to sit on the jury panel. They ask questions to try to learn about their background, whether they're being truthful, whether they think that they might be biased. And more importantly, from the defense side, they look at their life experience to decide whether or not it's somebody who they think could connect with the defendant, who would be sympathetic to the situation that the defendant found themselves in and ultimately find the defense credible. When you're the prosecution, on the other hand, you're looking for jurors who are more law and order, people who follow the rules, people who believe in the rule of law, and people who are going to go into the trial with a mindset that favors the prosecution in the sense that they tend to believe law enforcement testimony unless there's a reason not to. The only time that race comes up during the voir dire process is if there's an allegation by the defense that in some way the prosecution is trying to stack the deck by removing minorities or by removing people who the prosecution feels should not be on the jury for reasons that are discriminatory. In that case, the judge can actually question the witness and question the prosecutors or the defense about their reasons for trying to remove a juror. And if a judge finds those reasons to be impermissible, the judge can force the prosecution to accept a juror that they would otherwise try to reject.
Obviously, there are alternates in case something like this does happen, but dismissing a juror is not something a judge does lightly.
It's not an ideal situation from the standpoint of the judge to have to replace a juror mid-trial, because it does raise questions about not only the conduct of the individual juror, but sometimes it also raises a question about whether other jurors may have been infected by improper conduct by the juror who's replaced. For example, if the allegation is that a juror was communicating with somebody outside of the jury about the case or was receiving information about the trial other than what's being presented in the courtroom, that raises a serious concern that results in the removal of not only that juror, but sometimes judges then have to question the entire jury panel to make sure that any evidence that was not presented at the trial that may have come from the outside did not infect other jurors and has not tainted the entire jury.
All of a sudden, seeing that a juror has been dismissed after sitting there for weeks and weeks, does that have an effect, or could it have an effect on the other jurors?
Well, yeah, that's a great question, because the jurors obviously will be aware that there's a person who's been sitting there next to them for 6 weeks now, who's been sitting in the jury box, who's been spending time with them outside of the courtroom, and suddenly that person is not there, and the judge is not going to explain the actual reason for that juror's dismissal. Judges will typically tell other jurors that there are various reasons during the course of a trial that a juror might be replaced by an alternate, and that juror number 6 in this case is being replaced by an alternate without giving them reasons as to why that juror has been removed. But human nature being what it is, there's no question that jurors will talk among themselves as to why that juror has been removed. And it's just a distraction and an injection of information into the jury room that judges would like to avoid. So they really try not to remove jurors during the course of a trial, but in some cases it's inevitable. And in this case, there was this lack of candor that the judge found that this juror may not really be a resident of the Southern District of New York. And if the juror was not removed, if the juror was allowed to remain on the panel, that's something that I'm sure the judge was concerned would be an issue on appeal. And so the judge really has to protect the record. He has to protect the trial so that ultimately, however it turns out, it will stand up on appeal.
So now you have a 41-year-old black man being replaced by a 57-year-old white man, leaving just one black man on the jury. Is the change here an issue for appeal?
Well, I think we can expect the defense, if they get a conviction here, to raise it on appeal, certainly. But it's difficult for the defense to argue when a black juror is replaced by a white juror only on the basis of race, because what that does is it presupposes that a black juror would necessarily favor the defense simply because the defendant also happens to be black. That's not going to be enough to get a trial overturned. There has to be something more to it in order for them to really argue that they were unfairly prejudiced by the removal of that juror.
It's unusual enough to have one juror dismissed mid-trial, but now there's a possibility that a second juror might be dismissed. The facts are a little sketchy, but it appears that there are concerns that juror number 7 might have spoken improperly about the case.
When a juror is sworn in, they are given very strict rules that they are not to discuss the case outside of the courtroom. They're not to look at social media. They're not to read the news. They're not to talk about the case during their commute into the trial or on their way home. They're not to talk about the case with their spouse. And the judge will instruct jurors not to talk about the case with their fellow jurors until deliberations begin. They basically live inside a bubble and do not talk about what's going on in the courtroom. So they are under very strict rules. And sometimes in a high-profile case such as this, judges will even go so far as to sequester jurors, which means jurors do not get to live at home. They live in a hotel. They have no contact with the outside world. They can't watch TV. They can't read the newspaper. They are really cut off from all outside sources. so that their entire focus is only what is going on in the courtroom. Because at the end of the day, jurors have to make their decision about the guilt of the defendant or whether or not the prosecution met its burden of proof based solely upon the evidence that's presented in the courtroom and not based upon any outside information. Here, there is some allegation at this point that the judge is looking into whether or not a juror may have communicated with somebody outside of the courtroom, and it's a violation of their oath to provide any information about what's going on in the trial to anybody outside the trial. It's also a violation for that juror to receive any information about what's going on in the trial from sources outside of the courtroom. So this is a serious allegation that the judge is going to have to spend some time getting to the bottom of. The case cannot go on if there's the possibility that there is a tainted juror, because that could not only result in the removal of that juror, but the judge may well have to question other jurors to determine whether or not any information from outside of the jury room and from outside the courtroom may have tainted that jury, whether information that was not presented in the courtroom may have been discussed by jurors. This is going to be a bit of a sideshow. It's something that judges do not like to have to engage in because it's a distraction. It will slow the case down, and it may ultimately, in the worst case scenario, result in a mistrial, which means they would have to try the case all over again. So we'll have to see how this plays out. But the mere fact that there's a suggestion that a juror may have been communicating with somebody outside of the courtroom is a very troubling development for the prosecution.
Bob, do you believe that jurors really don't talk to anyone about the case, even when the case takes months? They don't go home and say something to their husband or wife?
Well, that is clearly what they are instructed to do. Now, whether they do it in actual practice, most of the time, the prosecution, the defense, and the judge don't really know. There's a reason why the judge is always reluctant to peer behind the curtain and find out exactly what's going on in the jury room, because once you start asking jurors questions about what's going on, you don't exactly know what you are going to find. So unless there is some real clear-cut evidence that a jury is doing something improper, that a juror is communicating with somebody outside of the courtroom, or that a juror has received information from outside of the trial that they shouldn't be receiving, judges are reluctant to go down the road to start questioning jurors during the course of a trial. But sometimes, like in this case, the judge simply has no choice. The judge can't ignore an allegation that this jury is possibly tainted, that one juror may have improperly communicated with somebody outside of the courtroom, and so he has no choice but to begin this process. The thing that troubles judges and troubles prosecutors is once you go down this road, you really don't know what you're going to find when the judge starts to question jurors. So that's why it's something judges are reluctant to do, and they only do it, as in this circumstance, where the judge really has no other choice.
So the judge here is dealing with a very high-profile case, obviously. There are news reports about every witness, et cetera. And this morning, the judge was livid, and he asked both the prosecution and the defense about an online article that appeared to include details from a sealed proceeding. He said, the court imposed a gag order on the government, the defendant, all attorneys for the defense, and anyone involved was made accountable. What happened here may result in civil or criminal contempt charges for all involved.
Well, you don't usually find defense lawyers or prosecutors talking about sealed proceedings with somebody outside of the courtroom. Lawyers generally know that that would be a serious violation, that the judge would take serious action against them, perhaps holding them in contempt or even a criminal violation for violating the sealing order and talking about a proceeding that was under seal with the media or somebody outside of the courtroom. But it can happen. And in a case like this, where the media scrutiny has been so intense, where there's really been a complete saturation of coverage of every day of this trial, of every witness, of people talking about them on cable news, in the print, on the radio, the news of this trial has really become almost a circus in the sense of the level of coverage here. And so there's a lot of information out there, and the judge needs to make sure that he maintains control of that courtroom. And that means not only controlling what information may get in front of the jury, but also controlling the lawyers and making sure that the attorneys are playing their proper role, arguing their case in the courtroom and not communicating with any outside sources improperly, and certainly not communicating about proceedings that were held under seal.
Thanks so much, Bob. That's Robert Mintz of McCarter English. Coming up next, Harvard versus Trump again. I'm June Grasso, and you're listening to Bloomberg. Harvard is the main target of President Donald Trump's efforts to force universities to crack down on anti-Semitism, remove perceived political bias, and eliminate diversity, equity, and inclusion programs. The university is already suing over the Trump administration's freezing of more than $2.6 billion in federal research funding. The latest legal fight concerns the administration's refusal to give foreign students visas to attend Harvard. Boston federal judge Allison Burroughs has already issued a temporary order on Trump's proclamation, and at a hearing yesterday, she extended that order until June 23rd, while she weighs Harvard's request for a preliminary injunction. Joining me is Bloomberg legal reporter David Voreacos, who was at that hearing in Boston. David, tell us about Trump's June 4th proclamation.
The Trump administration said that the United States was going to bar visas for foreign nationals seeking to enter the United States to study or do research at Harvard, and that the administration also had the ability to review current students and researchers already in the United States to see if they should be removed as well. And Harvard sued immediately, and Judge Allison Burroughs in Boston quickly entered a temporary restraining order, essentially maintaining the status quo and making sure that the Trump administration could not enforce the order.
So is the administration doing anything like this to any other university?
The administration is investigating a number of other universities and has indicated that it will suspend funding to other universities, but the extent of the broad-based assault on Harvard has no match at any other university in the United States.
So you were at the hearing yesterday. What was the main issue at the hearing?
The issue is whether Judge Burroughs should issue a preliminary injunction which would extend her temporary restraining order, and cutting through the legal language, should she continue to block the Trump administration from enforcing this proclamation while the litigation plays out. It would not be a final order, but it would give Harvard some breathing room so that it could plan. If the proclamation went into effect, it could not accept foreign students or researchers for the upcoming semester, and that could have a potentially devastating effect on its student population, its finances, and its research program.
I was surprised at how many students at Harvard are from other countries.
It's 27% of the population, which is a high proportion, but not as high as some other universities. But it also, would have a significant financial impact on the university.
So is the government's claim that Harvard is a national security risk? What is the government's claim here?
The government's made several different claims over the last couple of months. One is that Harvard has inadequately addressed the problem of anti-Semitism on campus. Harvard acknowledges that there have been problems on campus and that it's taken steps to address them in the area of anti-Semitism. The Trump administration has also said that there's not sufficient viewpoint diversity, that it's too much of a woke university, too liberal-leaning, and that it needs to increase its ideological viewpoint across the spectrum. The Trump administration has also said that Harvard has done too much research and taken too much money from the Chinese government in the hundreds of millions of dollars. And then the final area is that the Trump administration has demanded records from Harvard about how it's disciplined students who've gotten into criminal or other administrative problems at the school. The administration says that Harvard's only turned over records on 3 students, which is clearly inadequate, and that the failure to adequately disclose records on student discipline poses a national security threat.
Just say there is a lack of diversity. How does lack of diversity affect national security? How does, anti-Semitism affect national security? I just don't understand the connection between what they're arguing is wrong with Harvard.
As I understand it, what the Trump administration is arguing is not that all failings at Harvard pose national security risks. The national security risk that they are citing is that they're not turning over information on foreign students, which means that the United States cannot vet those students who are coming into the country or who are already in the country.
And what is Harvard's response?
Harvard's response is that this is all impermissible retaliation for Harvard exercising its First Amendment rights to hire the teachers that it wants, admit the students that it wants, and teach the curriculum that it wants, and that it refused the administration's demands in mid-April to make a number of changes. And because of that refusal, the administration has engaged in an unceasing campaign of retaliation with a number of punitive steps. And it says that the law is on its side when it comes to the First Amendment, that it protects academic freedom. And it says that its First Amendment privileges trump, if you will, the United States claim that the administration has unfettered ability to control visas and national security.
Was the judge tougher on one side than the other? Were her questions leaning in one direction or another? I know she did say, I can't imagine that anything you've described applies only to Harvard.
Right. It was a little hard to read Judge Burroughs, but given her track record in which she's sort of consistently ruled in Harvard's favor, I would bet that she's likely to grant a preliminary injunction here. But she clearly is troubled by this question of whether the Trump administration is, in fact, following the law in exercising its discretion to exclude a class of people who are entering the United States to study at Harvard. She asked a number of probing questions of the Harvard lawyer, suggesting that maybe it's a bit of a close call in her mind, but it was hard to tell for sure.
Tell us about what the requirements are for getting a preliminary injunction.
There are 4 legal factors, but the ones that really matter are the likelihood of success in the litigation as it progresses and whether the action causes irreparable harm to the party that's suing. And Harvard says that the harm here is overwhelming and devastating, and that they are likely to succeed in showing that the Trump administration is retaliating in violation of its First Amendment free speech rights.
What else has the Trump administration done to Harvard?
Primarily, it's frozen about $2.6 billion in research grants, which is the subject of a separate lawsuit that Harvard filed and that is also before Judge Burroughs. It's also been subject to different government investigations, and Trump has said that he's considering pulling the tax-exempt status of Harvard, which means the school would have to essentially pay a lot more money to operate.
It's not legal for him to direct the IRS to pull the tax-exempt status of a university, of anybody.
Well, they're trying to change the law that would make it legal. I'm not sure that it's legislation, but I think that they are posing new regulations through the Treasury Department. Right now, the procedure is that it has to go through IRS, and there's a whole long due process procedure that any organization that is threatened with losing its tax-exempt status has an opportunity to have a hearing. They can appeal, and it goes on for some time. As I understand it, Treasury Secretary Bessent would have that exclusive authority to determine whether an institution can maintain its tax-exempt status. I don't know how that's going to play out, but that's my understanding of where it's headed.
Are these all in front of Judge Burroughs because one is in front of her, so they're assigning the other ones to her too?
I assume that the clerk's office consider these to be related cases. And so typically civil litigation will move as a group if cases are related before a single judge.
Do you have any idea when she'll have an opinion on the preliminary injunction?
She indicated that she would rule by June 23rd, which is next Monday. There was a temporary restraining order that was in place until the end of the week. The government agreed to allow her to extend that until Monday, June 23rd. And then she said that she's likely to rule by then.
Do you know anything about the attorneys that are representing Harvard?
There are a number of attorneys in the litigation, and the one that argued on Monday was from Jenner & Block. So there were a number of Jenner & Block lawyers there. They're also represented by Quinn Emanuel lawyers, and people from the Harvard counsel's office were there. But the Justice Department had a single lawyer.
Well, as you know, the government team is often dwarfed by the defense teams in high-profile cases like this. And interestingly, Harvard is being represented by Jenner & Block, which was one of the law firms targeted by Trump, one of the law firms that fought back, and a federal judge struck down that executive order at the end of last month. Thanks so much, David. That's David Voreacos, Bloomberg legal reporter. During the June 1st episode of the Totally Football Show with James Richardson, a podcast produced by the New York Times, listeners in the Washington, D.C. area heard a mysterious ad.
Did you know that foreign investors are quietly funding lawsuits in American courts through a practice called third-party litigation funding? Shadowy overseas funders are paying to sue American companies in our courts. And they don't pay a dime in U.S. taxes if there is an award or settlement. They profit tax-free from our legal system, while U.S. companies are tied up in court, and American families pay the price, to the tune of $5,000 a year.
The 60-second spot highlights an emerging strategy, trying to turn consumers against the plaintiffs' bar and litigation finance. Joining me is Bloomberg Law senior reporter Emily Siegel, who's written about this. Emily, tell us about this ad and where it came from.
A colleague was listening to that podcast and sent me a recording of the ad, and it was an advertisement that was basically anti-litigation funding. They called them shadowy overseas funders and indicated that they don't pay any U.S. taxes if there's an award or settlement. And there was no disclosure on the ad, which is required by the Federal Election Commission, and so we don't actually know who was behind it.
I mean, how much do foreign investors invest in litigation financing? Do we know?
We don't really know. I think that there are some funders that have sovereign wealth funds involved as their investors, but we don't really know the extent of how much that's actually happening. So kind of unclear how often there are foreign investors involved. And also, if you speak to any funders, the investors don't really play any role in case selection or how the case proceeds or looking at documents. So even if there are foreign investors, at least from the funders I've spoken to, they say that there's no real involvement from any of the investors.
So what is the purpose of this ad on a podcast?
It seems to be pushing for a particular piece of legislation by Senator Tom Tillis, which would add a 41% tax on litigation finance profits. It doesn't name that bill, but it does say that there is a solution and it would be taxing the industry. And it also urged the listeners to contact lawmakers and Republicans on Capitol Hill who could make the measure go forward.
Tell us a little about that bill.
Sure. So basically, it would add at least a 41% tax. There are other provisions in the bill that indicate it could even be higher than that. And, you know, a lot of the funders in the states are really unhappy with it. It was recently, as of last night, included in the text of the tax package, the big, beautiful bill. And it was just updated, a new version of the tax and healthcare provisions, and it was added in there. So I think there's a lot of people in the industry, the litigation finance industry, who are concerned that this can end up going through.
So this would force foreign investors to pay taxes?
It would force all investors, all litigation funders, whether they're foreign or not, to pay this tax. And that includes hedge funds, it includes private equity firms that are also doing litigation finance. They would be taxed at this separate rate.
There have been efforts at tort reform for decades. How is this different from what we've seen before?
This version of the attack to litigation finance is new, but there have been, I think, at least 3 or 4 other congressional bills that have been introduced over the past couple of years. None of them have been successful, and they mostly focus on disclosure, which would mean that parties would have to file with the court whether they are receiving litigation funding. And so this is a totally different type of attack on the industry, and I think this one has funders more concerned because it has more of a chance of going somewhere if it's part of the tax package.
So with these ads, they're trying to turn consumers against the plaintiff's bar and litigation finance. I mean, is this an effort to turn the public against these large class action tort suits?
A lot of these funders are doing mass torts and class action lawsuits, but a lot of them are just doing, corporate business to business sort of litigation. One large business sues another. So I don't know if the public has enough knowledge about this entire industry. It's new compared to other industries, and I think there's not a great sense of what it is they actually do. And there's a lot of conflation between litigation finance and plaintiffs who receive some sort of loan against their settlement for paying rent, for their medical bills, which are completely different types of industries. So I don't know that there's a lot of information out there, and a lot of these, like the podcast ad, and there are other ads that I wrote about in the story that are sort of an attempt to educate the public on what litigation finance is, but it comes from a certain perspective.
What are the costs? I know that the Chamber of Commerce has done an analysis of how much the tort system actually costs.
Yeah, they say it could cost in each household around, I think, $4,200. And then it is basically saying that litigation finance contributes to the rise in lawsuits. It's hard to discern how they're getting that information if we're not really aware of how often litigation finance is used. So that's their calculations, and that the calculations from the U.S. Chamber of Commerce are often used in these advertisements.
Are there companies that are actively lobbying on this?
Yeah, I think, there are a bunch of different companies. I think Intel has lobbied on this. They're the recipient of a lot of patent lawsuits. Uber has funded one of the groups that is putting out advertisements, and they're also the recipient of a lot of lawsuits. So there are some big corporations. The insurance industry also, has put out letters in support of bills like the Tillis bill, and because they are usually, again, on the other side of cases that are being funded.
Now, there's a new group called Protecting American Consumers Together, or PACT.
Mm-hmm.
What's their goal?
So they seem to be sort of generally looking at tort reform and pushing for tort reform while also pushing for regulation of the litigation finance industry. And they do that through advertisements and education materials that they put out there. They say they were not behind this podcast ad. They do have some funding from Uber, and they launched in January, and they already had some success. There was a bill, tort reform package in Georgia that passed earlier this year, and it also included a litigation finance regulation provision.
There's another group, Make America Affordable Again. What's its push?
They have not, at least outwardly, put anything out against litigation finance, but they're pushing for something called loser pays, which would mean that the person or the entity that files the lawsuit would have to pay the other side's legal bills if they lose. It seems to be the majority of their ads are focused on loser pays.
And is that something that President Trump has commented on?
I think that he has commented on it a little bit. There was a press conference in January during the California wildfires where someone asked him about it, and he seemed to like the idea. He said it would cut down costs. So it is something that he's expressed an interest in. He has directed the Justice Department to demand bonds from court challengers when judges temporarily halt his policies, but I don't think he's actually put out anything explicitly about loser pays.
And are litigation funders doing anything to fight back?
Well, they have a group called the International Legal Finance Association, which does a lot of their lobbying, and they have hired a new Republican lobbyist named Pete Kirkham, according to a recent disclosure. So they are actively lobbying against this bill, and that's pretty much their goal. I attended a conference a couple of weeks ago where other funders were urging people to join the group as members so that they could pay dues to help, fight against this sort of legislation.
And as far as the ad itself, is it still playing?
So I reached out to The Athletic, which was where we first discovered the ad. They're owned by the New York Times. And they said that they had requested from their vendor to have the ad taken down. The vendor is a company called Acast, and they do a lot of podcasts. So I reached out to them, and they said they issued a takedown notice and that the ad would not play on any of their platforms anymore. It just had something it was an error. They would not say who paid for the ad.
So the mystery continues. Thanks so much, Emily. That's Emily Siegel, Bloomberg Law senior reporter. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.